Honorable Senators, when the business of this Senate was suspended, we were at second reading of bills. We were about to commence debate on the Magistrates Amendment Bill. Yes, sir. The chair recognizes Senator the Honorable Ryan Pinder.
Thank you. Thank you, Mr. Vice President. I appreciate that. Mr. Vice President, today I rise to move for the second reading of the Magistrates Amendment Bill 2022. The need for the amendments to the Magistrate Act is to update and modernize the law and to refine the law, all in an effort to accord with the changing requirements of our people and to advance the efficient and the effective administration of justice. It is the effective administration of justice that is paramount, and we should be committed to systematically adjusting the legislation and the procedures to ensure the greatest efficiency while not prejudicing due process. Mr. Vice President, this bill seeks to increase the financial thresholds of the jurisdiction of a magistrate to hear certain matters as follows. $5,000 in respect of small cause claims, claims in tort, and claims in contract. $10,000 in respect of actions for the recovery of money. $10,000 in respect of land disputes. $2,000 in respect of seizures under the revenue laws. $20,000 in respect of the chief magistrate and stipendiary circuit magistrates in civil proceedings. $10,000 in respect of circuit magistrates in civil proceedings. $1,000 in respect to the transfer of small cause claims from the Magistrates Court to the Supreme Court. $10,000 in respect of the removal of small cause claims from the Supreme Court to the Magistrate Court. $100 in respect of an appeal in matrimonial or civil matters heard by magistrates. The maximum penalties will now be amended as indicated. Fees payable to civil proceedings and sums recoverable for compensation to $1,500 for each case. Per diem penalty, which may be imposed by a magistrate for non-compliance, of $50. Value of a person's tools and implements of trade, which may be taken under distress issued by a magistrate, to $1,500. Compensation for loss of time of parties and witnesses attending for proceedings before the Magistrates Court and attorney costs to $1,000. Costs by way of a lump sum which may be awarded to $500. And finally, court and officers' fees payable in respect of civil proceedings. Mr. Vice President, the broadening of the jurisdiction of the Magistrate Court is intended to rebalance cases between the Supreme Court and the Magistrate Court in order to relieve the volume of minor disputes from the calendar of the Supreme Court. As we would know, the Magistrate Court is, in many instances, the primary court for many civil and criminal cases, and especially in civil matters operating more of a small claims court. The jurisdictional limits we seek to increase have not been adjusted in many years, and the operation of society has outpaced these limits. We look to rebalance the jurisdiction of the Magistrates Court to be able to serve its intended purpose, but in the context of today's society and what are the norms of today's society. This would in turn free up the calendar of the Supreme Court to hear more serious matters in which should be more expedited calendar. Mr. Vice President, we have had some new appointments to the bench recently. The Judicial and Legal Services Commission has recently made new appointments to the Magistrate Court, the Supreme Court, and the Prime Minister has made a new appointment to the Court of Appeal. I would like to recognize and congratulate all of the new appointees. Mr. Vice President, Chief Magistrate Joanne Ferguson Pratt has been appointed to serve as Acting Justice of the Supreme Court. Justice Bernard Turner has been appointed to the Court of Appeal as Acting Appellate Judge. Mr. Roberto Reckley will serve as the acting chief magistrate. Raquel Wims has been appointed as acting magistrate, and Lennox Colby has been appointed as acting magistrate in the firearms court. Although not intending to single out any one person, Mr. Vice President, I think it important to recognize the last appointment, Mr. Lennox Colby, in the firearms court is very important. This is because the firearms court is the designated court for crimes involving and constituting illegal firearms. This is a strategy of the Chief Justice to ensure that priority is given to firearms matters, with swift justice occurring and quick trials happening. The possession and use of illegal firearms is plaguing our society, and this is one tool in the toolbox available to us to address this vexing issue. Mr. Vice President, having an avenue for quick trials is also important in order to address the issue of bail being given out to accused, especially those with multiple convictions or multiple charges related to multiple incidents. Mr. Vice President, given the public conversation that occurs with respect to bail, and given the utterances by the Commissioner of Police on matters related to bail, I think it important to speak to bail and what we are seeing in the courts with respect to the granting of bail, and more importantly, with respect to the denial of bail. First, let me set out, for the benefit of the Bahamian people, because this could get rather complex at times, the legal and the constitutional framework that applies to bail. On the right to bail, Mr. Vice President, Article 20 of the Constitution gives all persons accused of a criminal offense the presumption of innocence until a court of law finds them guilty or they plead guilty. Article 20, subsection 2 provides every person who is charged with a criminal offense shall be presumed to be innocent until he is proved or has pled guilty. Furthermore, Mr. Vice President, Article 19(1) of the Constitution is applicable and specifies that no person shall be deprived of his personal liberty, save as may be authorized by law in any of the following cases. And two of the examples include, which would be subpart C, for the purposes of bringing him before a court in the execution of the order of a court, and what would be subsection D, upon reasonable suspicion of his having committed or being about to commit a criminal offense. Article 19(3) of the Constitution reads, any person who is arrested or detained in such a case as I have just mentioned of this article, and who is not released, shall be brought without undue delay before a court. And if any person arrested or detained in such a case as is mentioned is not tried within a reasonable time, he shall, without prejudice to any further proceedings that may be brought against him, he shall be released, either unconditionally or upon reasonable conditions, including in particular such conditions as are reasonably necessary to ensure that he appears at a later date for trial or for proceedings preliminary to the trial. Mr. Vice President, those are the constitutional provisions that are directly applicable to those that are accused and the framework of when his civil liberties are to be advanced, and in that context, bail would be applicable. Mr. Vice President, to continue into the Bail Act, which is Chapter 103 of our statutes. Section 4.2 of the Bail Act reads as follows. Notwithstanding any other provision of this act or any other law, any person charged with an offense mentioned in Part C of the first schedule shall not be granted bail unless the Supreme Court or the Court of Appeal is satisfied that the person charged in subsection A has not been tried within a reasonable time, or subsection C, should be granted bail having regard to all the relevant factors, including those specified in Part A of the first schedule and Section 2B. I will discuss those sections in a minute. But this section goes on to say, and where the court makes an order for the release on bail of that person, it shall include in the record a written statement giving the reasons for the order of the release on bail. So when bail is issued, it is the obligation of the judge to detail the reasonings for bail in the matter. Section 2B of the Bail Act, 42B, goes on to say, and this is an important provision, for the purposes of 2C, in deciding whether or not to grant bail to a person charged with an offense in Part C of the first schedule, the character and antecedents of the person charged, the need to protect the safety of the public order, and where appropriate, the need to protect the safety of the victim or victims of the alleged offense are to be primary considerations in the determination. Again, the character and antecedents of the person, the need to protect the safety of and public order, and the need to protect the safety of the victim or victims of the alleged offense. You will recall that this also refers you to Part A with respect to factors to determine the denial of bail. And the relevant sections of Part A, this is the last statutory lesson in my contribution. Part A has factors to determine the denial of bail, providing in part, and I quote, in consideration whether to grant bail to a defendant, the court shall have regard to the following factors. So these are obligatory. A, whether there are substantial grounds for believing that the defendant, if released on bail, would fail to surrender to custody to appear for the trial. That has to be considered. Whether the defendant will commit an offense while on bail. That should be considered. Or whether the defendant would interfere with witnesses or otherwise obstruct the course of justice, whether in relation to himself or any other person. So obstruction of the case in some form or fashion. Part A also says that we should consider whether the defendant should be kept in custody for his own protection, or where he is a child or young person for his own welfare. So again, the court shall determine whether the defendant should be kept in custody for his own protection. That's an important piece as well. Mr. Vice President, there's been much discussion about whether, in the Bahamas, we should automatically deny bail to people charged with murder. We have seen that discussed in the press, and I think even the Commissioner of Police has alluded to that. In Trinidad, a law was passed by its parliament and provided that bail may not be granted to any person charged with the offense of murder. So Trinidad actually passed a law saying that bail should not be and cannot be awarded if you are charged with murder. This was challenged, Mr. Vice President, in the case Attorney General of Trinidad and Tobago versus Achille Charles. The Court of Appeal allowed the Charles appeal to the Privy Council. The Court of Appeal held, this was their determination, that the applicable section of the Bail Act, which I just referred to, was unconstitutional. It It was unconstitutional because, among other things, it derogated from the fundamental rights and freedoms in their Constitution. Now, you'll recall in the beginning of this discussion, I gave you the fundamental rights that are laid out in our Constitution that would be applicable to matters with respect to bail. The Privy Council, upholding the Court of Appeal, ruled that the board accepts that the very severe consequences flow from the infringement of fundamental rights and freedoms by the bail provision that the Trinidad and Tobago Parliament put into force, including the undermining of the rule of law. So the Privy Council themselves said, making a law that automatically denied bail for those charged with murder undermined actually the rule of law. That's a rather strong statement. Therefore, under this case, the Privy Council has ruled that the automatic denial of bail for murder is unconstitutional. This determination would most likely flow with respect to the fundamental rights found in the Constitution of the Commonwealth of Bahamas. So those who would advocate for the automatic and mandatory denial of bail in the case of murder, that position is unconstitutional as laid out by the Privy Council, our most high court. Mr. Vice President, our current laws, as I went through earlier, both the constitutional framework and the Bail Act, either allows for a more restrictive granting of bail than we have seen over the years in the Bahamas. It permits a more restrictive granting of bail than we have seen the courts delivering, especially considering the types of crimes and the alleged criminals that we have seen in these matters, such as repeat offenders, multiple offenders, and violent offenders. Those are usually the subset that really get people, rightfully so, anxious, to say the least, about the issue of granting of bail to alleged criminals. Mr. Vice President, we have recently seen a trend of cases in our Court of Appeal that are instructive on circumstances where bail should be denied. And I encourage our lower courts to review the chain of cases and their reasoning and consider them in all matters involving violent crime and repeated offenders where appropriate. These cases, Mr. Vice President, have focused on denying bail in two specific instances that are provided in our law and our Constitution that I discussed prior. These two instances of focus by the Court of Appeal are the need to protect the safety of the public order and whether the defendant should be kept in custody for his own protection. So those are the elements I want to focus on, which are justifiable grounds under our Constitution and our Bail Act for the denial of bail to an accused. In 2022, just last year, in Denton Grant versus the DPP, the Court of Appeal held that once, and I quote, once there is a basis that an accused person may be attacked on bail, maybe, the court is obligated to deny bail to that applicant. The attack on the appellant in this case occurred, there was an attack on the appellant in this case that occurred days earlier. And that was used as a basis to deny bail. There is a caveat, however, that we must consider. A caveat can be applied if the appellant can demonstrate to the court that notwithstanding a finding that his life may be in danger if released on bail, he is able to minimize that risk. So that now turns over to the accused to prove that there are things he can do to minimize that risk. In a small country, that can pose certain difficulties, but the presumption is then given to them to prove that. The Court of Appeal upheld the denying of bail on the grounds that the appellant's life may be in danger. The lower court found that the incident occurred in a hotspot for crime, and there was a strong possibility of retaliatory attacks against the applicant. In his concurring opinion, the Honorable Sir Michael Barnett also provided that, and I quote, "There is not only a risk of the appellant's safety if granted bail, but also a risk to the public's safety. Any retaliation against the appellant puts members of the public at risk who may be in the area where any attack on the appellant may take place." This case, Mr. Vice President, as a learned friend, demonstrates that the risk of retaliation against an accused murderer is grounds to deny bail both to protect the safety of the public order as well as for the accused's own protection. Mr. Vice President, we go on. In this year of 2023, in the case of Stephen Davis versus the DPP, the same Court of Appeal upheld a denial of bail where the lower court found that an accused who was on bail for two separate offenses of murder was a threat to the public safety and public order. So in this situation, the accused was accused of murder, granted bail, accused of a second murder while on bail, and then came back to get bail again. And the court denied the bail, and then he appealed to this Court of Appeal. The court found, this is important as well, the court found that the use of an electronic monitoring device, we call them ankle bracelets, was not an acceptable condition to ameliorate the court's concerns because the second offense occurred while the accused was wearing such a device. I mean, if that doesn't say whether the use of a monitoring device is sufficient to allow you to be granted on bail, I don't know. This is a Court of Appeal. This is the Court of Appeal. This case demonstrates when someone is accused with multiple offenses of a violent nature, they are a threat to the public safety and should be denied bail. Again, this year in 2023, this is a great trend, right? I commend the Court of Appeal. In 2023, in the case of Alcott Fox and the DPP, this same Court of Appeal upheld a denial of bail where the appellant was accused of murder of a person in Exuma, who likewise was on bail for murder. There was evidence that the applicant was involved in organized gang activity, and the circumstances of the case raised the specter of retaliatory killings. So that's what the facts were before the court. The accused was involved in organized gang activity, and the facts of this case demonstrates a retaliatory killing. The court made the point, and I quote, "Retaliatory killings raise the specter of further retaliatory killings, which from the evidence in this matter can extend to the smallest family island community. This raises the issue of not only the safety to the applicant, but the safety of society. On this basis, bail was denied. This case demonstrates that, one, affiliation with gangs and the possibility of retaliatory killings are grounds to deny bail, both to protect the safety of the public order and for the accused's own protection. Mr. Vice President, these are all recent cases, within the last 2 years, by the Court of Appeal on the denial of bail for violent offenders. This demonstrates that our law does allow, as it's written now, our law does allow for denial of bail in certain circumstances, and these cases frame the circumstances which are appropriate for such denial. These circumstances are areas where we see public criticism in the granting of bail by our courts. In instances of repeat violent offenders, instances of gang activity, and instances of perceived retaliatory killings. The Court of Appeal has ruled. They have laid out the framework in a series of well-reasoned cases. Lord knows if a commercial attorney like myself could follow them. You know the Court of Appeal is doing a good job laying out the circumstances in which you should deny bail to an accused. And again, they focus on two important areas: to protect the accused and to protect society, the public. I encourage our lower courts to study these and other cases and make the appropriate decisions in the denial of bail in appropriate circumstances. Yes. I think it important to make the point that the grant of bail is not a determination of innocence or of guilt. No. It is simply an indication that the parameters have been and are in place to assure an accused person's attendance at trial. It should not be for the public to use this as an indication of guilt. It's important to say that, because I started out this communication that you are constitutionally presumed innocent. I also want to implore on our people, please avoid the desire to retaliate in crimes. Vigilante activity is also a crime, and our people, by and large, should avoid the desire to retaliate against those that might have done them wrong. It's important to communicate that as well, because we see in a lot of these instances, and I gave specific examples of retaliatory activity and retaliatory killings. So I thought it appropriate, Mr. Vice President, to give that layout with respect to bail, because there's a lot of discussion, and rightfully so. It's an important issue. And there are a lot of instances where bail may have been granted where, according to what I just laid out, it shouldn't have. And that is right to discuss as well. But I think it's important not only for the judiciary to understand where our Court of Appeal is taking us, but it's important for the general public to understand the framework of our laws with respect to this important matter of granting bail, especially in the context of violent crimes. Mr. President, before closing, I would like to address one additional matter that has been frustrating to a constituency of our society that by their geography alone is at risk of having justice delayed and is challenged at times with the access to justice. This would be our family islanders. Recently in Eleuthera, but I'm sure it has happened in many other islands, the circuit magistrate canceled their trip without notice, leaving scores of persons and matters unattended to. Now, I could understand the occasional situation in which this might happen, given the challenges at times of logistics to our islands that we experience when traveling to these islands. I can understand it on occasion. However, this has been a repeated occurrence for Eleuthera. creating immense frustration and delay in the administration of justice. We cannot sit by and allow this injustice to continue. I have raised this issue with the Chief Justice. To leverage the administration of justice in our family islands, the Chief Justice and myself have committed to build out the remote court system throughout the country. I promised this before. It's still not done. That was under a prior Chief Justice. We have recently spoken and reinforced our commitment to fulfill this mandate, the current Chief Justice and me. We will secure the necessary IT equipment and facilities to allow for remote hearings and eliminate the need for magistrates to travel the islands to have circuit courts. I'm sure this has happened in Long Island. The frustration is real. We constitutionally should give access to justice without discrimination across our country, whether an archipelago or a fixed place. It is our commitment to do so. By putting in the framework for remote hearings will allow us to go a long way in addressing the delays and the backlog in court matters throughout our country, and ensuring the recent frustrations that the constituents and Bahamians in Eleuthera are not repeated. Mr. Vice President, although we all agree this is a positive legislation initiative, I don't think we have any objection from the other side. I think it important to emphasize that the advancement of the efficient and effective administration of justice cannot fully be accomplished by the executive or the legislature, although we will do everything in our power to try to do it. The judiciary and the private attorney practitioners also need to take some responsibility. Timelines must be reduced to advance the effective administration of justice. And the private bar has the obligation to achieve this as much as any other avenue of justice in our society. Private practitioners have a responsibility to advance matters in a proper and an expeditious way. Feedback received would suggest that private practitioners draw out court matters unnecessarily. And I think the time frames for concluding hearings is evidence of this. Matters should be prepared and ready for trial much quicker. And I ask the bar and private practitioners to take some responsibility in this regard. They have an obligation to the administration of justice as well. I also encourage the judiciary to recognize these clear efforts to delay by the private bar and to put in place adequate penalties against delay or adequate encouragement for the expeditiously adjudication of matters. Mr. Vice President, I didn't say it was all their fault. I said they have to take a certain responsibility because some of it could be, and in practicality, is their fault. And that's why I encourage the judiciary to put adequate penalties in place or adequate encouragement to ensure that people are ready in a reasonable and expeditious way. Let me tell you a story before I conclude. Let me tell you a story. And I'm sure the Prime Minister wouldn't mind me saying, this is a short one. Prime Minister at least once a month sits me down. Says, what's going on with these trials? Why do they take so long? Right? He says, I remember when I practiced and I had a murder trial without stenographers and written notes. He says that he would be prepared and his murder trials would take no more than 2 weeks, start to end, decision made. Today, you're looking like if you can get through a murder trial in a year, you're doing well. Right? You're doing well. I'm talking about the trial. Not the delay of getting on the calendar, the actual trial. Oh, we should go back to being brave when the Prime Minister was a practitioner and we had a more expeditious administration of justice in this country. No pun intended. Mr. Vice President, the Magistrates Amendment Bill 2022 is an important bill to add to the toolbox to advance the efficiency of the judicial system. Broadening the jurisdiction of the magistrate court will allow more disputes to be heard there, relieving cases on the calendar of the Supreme Court. This has the support of the current Chief Justice, and it had the support of the former Chief Justice. I have spoken with the current Chief Justice on the transition to broaden the jurisdiction of the Magistrates Court, and we will do so in an orderly fashion, ensuring the private bar is completely informed and involved in this process. With what is anticipated to be an increase in civil and commercial matters now in the Magistrates Court, as we have expanded the amounts where the Magistrates Court can hear these matters, the Chief Justice and I are considering a designated civil magistrate to hear these matters. Right now, magistrates reserve a time period in their calendar, an hour a day or whatever it might be, to hear civil matters. This should increase the volume of civil matters now in the Magistrates Court. So what we are considering is designating a civil magistrate to be able to have those matters heard there. This might allow us to place a magistrate who has the acumen, interest, and expertise in commercial and civil matters. And this should go a long way to addressing smaller commercial disputes and getting them through the system and on to normal life. So I thank you for the time. I know I was a little long, but I think it was appropriate what I had to say. And Mr. Vice President, I want to thank you for your indulgence and the indulgence of the other side. And I hereby move for the second reading of the Magistrates Amendment Bill 2022. Thank you.
Is there a seconder? The chair recognizes Senator the Honorable Darren Pickstock.
Thank you, Mr. Vice President. Mr. Vice President, I shall not be long. The Attorney General quite ably laid out what the amendments to the Magistrate Courts bill entailed, and he quite ably addressed a very important issue, societal issue, and that is that of bail. And so, I mean, I must commend the AG again. I mean, you know, I have to. I mean, these are important matters that affect our society on a daily basis, right? And so, you know, we cannot, you know, let that go without saying thank you. I would like also to join the Attorney General in congratulating Mr. Joanne Pratt, Mr. Turner, Bernard Turner, Roberta Reckley, Raquel Wims, and Lennox Colby. We all owe our public servants a debt of gratitude. Mr. Vice President, the amendments to the Magistrate Court Act must come as a welcome breath and relief to hundreds of Bahamians. Finally, by the passage of these amendments, the Magistrate Court is increasing the dollar amount of civil claims as the AG ably laid out, and the cost of service documents to initiate such actions. The Honorable Attorney General has competently dissected the Act and shown us the new alignments. For so many years, Bahamians who were aggrieved in these areas discovered that the damages they were seeking were out of the ambit of the magistrate's court quota. Those Bahamians who still had the patience and the financial durability turned to the Supreme Court. We all know there is a huge cost factor involved in such civil matters between the lower court and the upper court. And of course, there is the timing, the crowded calendar on the registrar's desk, which pushes such matters along rather slowly. I am sure some will suggest that the raising of the bar on the amount of the civil claim one can pursue in the magistrate's courts will also increase the workload of the lower courts, given the frequency of such occasions in this jurisdiction. I had in my notes to suggest that the Attorney General that he should consider an increase in the magistrate's complement, but again, he has already very ably indicated that there are new appointments, and so we thank you for that. Mr. Vice President, having said that, the amendments to the Magistrates Court Act are a welcome relief. I am sure everyone in this place has a hope that the energies and culture and the misappropriations which caused these amendments to be necessary will dissipate, and we will awake up in a kinder, gentler, honest nation where mutual respect is a unique and glorious national character, where Bahamians swing for the success of each other. I thank you, Mr. Vice President.
It has been moved and seconded that the following bill be read a second time and committed. A bill for an act to amend the Magistrates Act. As many, the chair recognizes Senator the Honorable Michaela Barnett Ellis.
Thank you, Mr. Vice President. I think I join with the other members on this side as we say, wow, we've never known Senator Pickstock to be so brief. I want to join with you, Mr. President, Mr. Vice President, and my other Senate colleagues who welcomed the summer interns from the Cabinet Office. You may not know this, but I was once a summer student at the Office of the Attorney General, 2 summers actually. And it was an eye-opening experience in terms of the administration of government and the work of the Attorney General's office. And so I commend to them that they take every opportunity to absorb as much as they can whilst at the Cabinet Office. I'd also like to say congratulations to the new judicial appointments. The work of the judiciary can never properly be remunerated, and so I have to thank them for their service, because it is it's more than a labor of love, the amount of work that goes into what they do. Mr. Vice President, it is always a pleasure to come to this place and make laws for the peace, order, and good governance of our beautiful Commonwealth of the Bahamas. I think it will come as no surprise, but I love the law. I love that legislation is created and drafted to meet the needs of a country, and how legislation reflects the aspirations of a country. Earlier this week, the Member of Parliament for Angliston, during the Parliamentary Services Bill debate, shared that the first piece of legislation dealt with in our ancient House of Assembly was legislation dealing with the regulation of slaves. It says a lot about what the legislative priorities were at the time, and though I was disheartened, I was not surprised. And I have to say, thankfully, we have evolved significantly. I think, though, that it is important that we pass laws that actually do what we want them to do. And I know I've said in this place, for example, with relation to the Coroner's Act, that sometimes we pass legislation that doesn't actually cure the mischief that we are seeking to resolve. But we are in this place to make laws and make lives of the people who live in the Bahamas better. And I've spoken in this place about the tabled Protection of Violence bill. And I've spoken in this place about the deficiencies of that bill. And I cannot address this upper house today and ignore the comment that was made in the House of Assembly yesterday about my position on the Protection of Violence bill. The member for Golden Gate said yesterday that I had not raised any concerns about the Protection Against Violence bill. Mr. Vice President, I'm sure you all will know here that in my budget debate, I called for the government to engage in a process of consultation on the Protection Against Violence bill. I said, and I'm quoting from my budget contribution, as I conclude, I want to address the tabled Protection Against Violence bill. For almost 10 years, we've had a draft gender-based violence bill that was drafted by the foremost stakeholders to international standards. The draft gender-based violence bill was extensively circulated for consultation and was exhaustively discussed and revised. After nearly 10 years, in response to the escalation in violence against women and children, almost all stakeholders had clamored with a united voice for the passage of the gender-based violence bill. The government had and continues to have a clear mandate on the passage of that bill. And yet, for reasons as yet explained, this administration has shelved the gender-based violence bill and tabled a new bill to address the issue of domestic violence. It is apparent just by the size alone of the new bill versus the former GBV bill that the new bill is less comprehensive than its predecessor. It is 42 sections long as opposed to 55 sections. It is 24 pages long as opposed to the 68 pages of the gender-based violence bill. What have they removed from the former vetted and approved bill, and why was it taken out? I went on to say, Madam President, through you, I'm asking the executive to engage stakeholders and explain why they walked away from the existing draft legislation and explain the thoughts behind this draft so that stakeholders have the opportunity to intelligently consider and intelligently respond to the bill. It would seem that the most expeditious course would be to pass the existing gender-based violence bill. This would allow the government to check the necessary treaty boxes, and it would deliver what the NGOs and other stakeholders have been clamoring for without further delay, which will result from a new round of consultations on the new Protection Against Violence bill. Therefore, Madam President, I'm asking the executive not to discard over 10 years of work. Be humble enough to recognize that they do not have the monopoly on intelligence and wanting what is best for the Bahamian people, especially the most vulnerable. And I'm asking that they table and pass the existing gender-based violence bill. But clearly, the Senate is not must-see TV for the member of Golden Gates. But my comments were also carried in an article which was published in the Tribune on the 30th of June, 2023. And I can table that article in this place. 4 days later, I was invited to the special forum on the Sexual Offenses Amendment 2022 and the Protection Against Violence Bill 2023. At that symposium, I asked the first question during the question and answer period. I asked point blank why the Law Reform Commission had abandoned the gender-based violence bill. I asked why sections of the statutory professional duty of care were not included in this act, and the provisions about giving evidence via video link were not included in this act. and the Federation of Community Organizations was also not included in the draft act. On the 19th of July, that was when we were here last week, I said, there are daily reports of women and children who are victims of sex crimes. Yet rather than help them in a meaningful way, this government has fiddled just like Nero fiddled when Rome burned. It is not as if this government is fiddling because they do not know what to do. There is a comprehensive gender-based violence bill drafted by our foremost experts. And it's not even as if it was an F&M bill. It was drafted under the 2012 PLP administration. But this administration, without any real explanation, instructed law reform to abandon the bill and draft a less comprehensive bill, which mainly articulates rights that we have already articulated elsewhere. On Tuesday, that was 2 days ago, I also mentioned the much-needed gender-based violence bill and that fact that it was a piece of groundbreaking legislation. Every time that I have come to this place since the tabling of the Protection Against Violence bill, I have voiced my concern over the departure from the gender-based violence bill. But alas, I think this is a prime example of a woman's silent voice. We can say something over and over again, and it is only heard when a man repeats the same thing. I raised concerns about this bill in the Senate and in the public in the presence of the Minister of Social Services, the Minister of State for Social Services, the spouse of the Prime Minister, the Minister of State for Public Service, and our President of the Senate. But it was only when the Honorable Michael Pentard quoted me in the House of Assembly that my concerns were heard for the first time. Therefore, the Member of Parliament for Golden Gates, the Minister of State for Public Service, had incorrectly stated in that place below that I have not said or done anything with relation to the Protection Against Violence bill. I have said before, chewing gum and walking at the same time requires you to pay attention. When we meet again, I will in detail point out the differences between the gender-based violence bill and the Protection Against Violence bill. I now turn to the Magistrates Act. Mr. Vice President, God works in mysterious ways because I've spent the last 2 mornings in the Magistrates Court dealing with a matter involving allegations of domestic violence. The Magistrates Act is being substantially amended to increase the jurisdiction of the Magistrates Court. I support this amendment. In fact, I would like to expand the Magistrates Court further. Most persons who come into contact with the judicial system in the Bahamas come into contact with the Magistrates Court. For criminal matters, it is the first point of contact. For most contract, rent, and damage dispute, the Magistrates Court is the appropriate jurisdiction. For domestic violence protection orders, unless the parties are getting divorced, the Magistrates Court is the jurisdiction. Applications for child support are heard in the jurisdiction of the Magistrates Court. With the volume of family matters being dealt with by the Magistrates Court, we are past the point of needing a Magistrates Court complex that deals exclusively with these matters. The Magistrates Court is meant to be a layperson-friendly atmosphere so that persons can have access to the justice system with or without a lawyer. But unfortunately, the services of the Magistrates Court are overstretched and leaves much to be desired by attorneys and laypersons. Applicants and respondents, virtual complainants, and the accused are all forced to wait in the same waiting area near the entrance to the courtroom. With little supervision in the area, it is an environment primed for intimidation and interference. Parties often wait long times for their matter to be heard, and then the matter is often adjourned for circumstances which are outside of anyone's control. This week, because my client had a lawyer, her matter was heard first. On both Wednesday and Thursday, our matter was before the magistrate from 10 in the morning to 1 p.m. The court needed the entire morning to adjudicate on one matter. And I would be remiss if I did not admit that I felt bad for the other matters that sat there and waited whilst our matter had to be determined. They spent their entire day in the waiting area, probably in close proximity to the person they were bringing to court or the person who brought them to court. If you've ever walked through the waiting area in the South Street complex, you can cut the tension in the air with a knife. We are passing legislation to expand the work of the magistrates' court, but we're not addressing the issues that impede the work of the court at its existing levels. The magistrates' court suffers from a lack of resources. The draft court services bill would give the judiciary, the co-equal third branch of government, the autonomy it requires so that it can have control of its access, of its resources, and the power to administer and control those resources. At my first sitting in this honorable place, the resolution to create a committee for the management of the House of Assembly was debated. Colleagues on both sides of this ancient table expressed the importance of the legislature as a co-equal branch of government being treated with the appropriate amount of dignity, which includes the ability to manage its own resources and govern its own policies and procedures. These arguments apply equally to the judiciary. Multiple administrations have left the draft court services bill in the file cabinet of the Law Reform Commission. And in fact, it's probably the same cabinet with the amendment to the Sexual Offenses Act and the Gender-Based Violence Bill. I'm not one for metaphors, but growing a tree without ensuring the health of its roots and branches is counterproductive. This thing goes with sense. Mr. Vice President, the continued development of the processes for the administration of justice is paramount to the development and maintenance of an efficient and fair justice system. This work is continuous, and it is without glitz and glamour. The dedicated staff of the Office of the Judiciary throughout the Bahamas work tirelessly to assist countless Bahamians and residents that come to the court for relief. They provide services for persons who are frustrated and discouraged. Having come to the court for relief is never a high point in somebody's life. The judiciary staff dutifully carry out their assignments, often giving invaluable advice from their many years of experience. I wish to publicly thank them for all the assistance and advice they have given me during my almost 15 years of practice. I want to say a special hello to the staff at the Magistrates Court South Street Complex. It is always good to see their familiar faces, and even though it was wet and rainy on the outside, the smiles that greeted me were sunshine on a cloudy day. Mr. Vice President, I love this country with all my heart. There is no place like home, and I support any piece of legislation that will improve the lives of the persons that call this place home. Thank you.
As many,
Just a quick wrap up. Just on a couple of things that were brought up by my good colleague on the other side. So I think one point she raised is always a vexing issue, and that's the infrastructure of the courts. The infrastructure doesn't seem to grow with the number of cases that are heard, and we appreciate that. In my budget contribution, you would have heard me speak in detail about our plans for a new judicial complex, giving the infrastructure that is necessary. You would have also heard me speak about the space reserved for a new family court, which would include all of the support mechanisms that a family court is proper in the family court setting. That would include mediation. That would include social services support. That would include all of the ancillary agencies that should be there to support a family court. So we're looking to do that, and we will do that as well. That will get done. It's a matter of high priority for the Chief Justice. So we understand the current frustrations, but we are working towards addressing that. The last point that I think that the good senator raised has to do with the court services bill. We have it, as you would know, tabled in the House of Assembly for debate. The Chief Justice supports it. The Chief Justice, on coming to office, asked for some time to review it so he can make any comments that he had on the bill as Chief Justice, which he has. And we can fully anticipate debating and passing that piece of legislation in the fall of this year. Mr. Vice President, thank you very much.
It has been moved and seconded that the following bill be read a second time and committed. A bill for an act to amend the Magistrates Act. As many are in favor say aye. Those who oppose say nay. The motion is carried. Ordered that the bill be read a second time and committed.
A bill for an act to amend the Magistrates Act.
For the second reading of bills,
Mr. Vice President, I move that the business of the Senate be now suspended until 3 p.m. on Monday, 31st of July, 2023.
is there a seconder? It has been moved and seconded that the business of this House be suspended until 3 o'clock p.m. on Monday, the 31st of July, 2023. All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. The business of this House has been adjourned until the 31st, suspended until the 31st of July, 2023 at 3 o'clock p.m.